How much? Enough where we can conduct a hearing where you can understand?
Need interview
You need an interpreter?
because I cannot hear you. I don't have the eardrum.
What?
I don't have an eardrum.
He doesn't have an ear.
I see. So is it more a hearing issue or is it you can't speak English? Which is it?
Or you can dismiss the room.
No, I can't do that. I can't do that. Did they offer you anything? Ooh, your record's bad, huh? Your record's bad. Bad. Why are you driving so fast? I said your record's bad. I don't know what to tell you. They're not going to dismiss it. They're not going to
I don't have both eardrum. Only I hear with the echo.
They offer you anything today?
Don't be called Woody, man.
Yeah, Lieutenant, your name?
Lieutenant David Toller, Whittier Police
Did you
Department.
offer him anything today?
Yes, Your Honor. The problem was that he was questioning the circumstances of the stop and thought that he was racially profiled.
Oh, boy.
and-
Okay. All right, good enough. We'll just set a formal hearing or an informal hearing. We will set an informal hearing.
You hear him in formal hearing?
Or just
the
the
officer, like we spoke about.
Or you tell the story, then you can dismiss the room.
I'm not dismissing
Tell
this.
the story.
Come
I
on.
already told you. So.
I said you had to have the officer present because I wasn't there, remember?
Yeah, well, you can do either way.
We're gonna set an informal hearing. We'll set an informal hearing.
Guys, today we are stepping inside a courtroom exchange that starts off as a routine traffic matter but quickly turns into something much more unusual. Right from the beginning, the judge struggles to understand whether the defendant is dealing with a hearing issue or a language barrier. As the conversation unfolds, the judge reviews the defendant's driving record and immediately notices a troubling pattern. What seems like a straightforward hearing begins taking a different direction when the defendant hints that something unfair may have happened during the traffic stop. The tension slowly builds as both sides try to understand each other, setting the stage for a courtroom battle that is far from over.
Informal hearing date, go down the hall, get your notice.
Can judge bring the federal agents who racial reason discrimination? He can order.
I told you to make a complaint with the police department regarding that.
No, it's not punishment, it's federal.
Listen. I'm gonna set an informal hearing date. Your record leaves a lot to be desired.
Can you?
Now, you come back on the date of the hearing.
I know, Judge, but
I haven't heard anything yet, sir. I can't just start throwing out a case because you say there was racial profiling.
but you can bring the federal agents for racism and the discrimination. The police officer racism and discrimination. I don't want an internal investigation. I want a federal government to jump in.
Well, I don't know what you're asking me. You have the right to make complaints with any.
Racism and the discrimination. So I want a federal government to come in here, hearing day, then federal government, they can charge a police officer.
I'm gonna listen to the evidence.
Police not stop me behind, he come in.
I'm gonna hang on. I'm gonna listen to the evidence. And I'm gonna make a determination as to whether or not you had defective equipment, whether or not you had proof of insurance, and whether or not you committed the offense of improper lane use. That's all I'm doing. If you've got a complaint to make, you can go to whatever agency you want to make your complaint with, but don't ask me just to throw this out. I don't even know anything about the case. So we'll give you a hearing date. What date is that going to be, Heather?
Yeah, but.
That'll be May 26th at 1 o'clock.
May 26th at 1 o'clock.
Now the situation takes a dramatic turn. Instead of focusing solely on the traffic violations, the defendant begins pushing a much bigger claim, insisting that he was racially profiled and demanding federal involvement. The judge remains firm, explaining that allegations alone are not enough to dismiss a case and that evidence must be presented through the proper legal process. As the defendant repeatedly asks for federal agents to step in, the courtroom atmosphere becomes increasingly tense. This moment highlights the clash between personal belief and courtroom procedure, with the judge trying to keep the discussion grounded in the law while the defendant continues pressing for a broader investigation.
May 26th at 1 p.m.
Well, you're gonna be testified, so federal government here, then they can charge the police. Then he did the race,
Listen,
religion, or discrimination or not.
Listen,
They know, federal.
Listen.
government, They know.
listen.
This is a local government, but discrimination and race, religion is a federal.
I don't know what you're talking about. I don't know what you're talking about. They wrote you a civil infraction charge. I'm gonna listen to them, and I'm gonna listen to you.
He come,
Sir, the officer's not here right now. The officer is not here. When he shows up, I'll
okay,
listen.
we do that after that, okay.
We're gonna do it May 26th at 1
Okay,
p.m.
we're gonna record the police officer, then we go into the federal.
11.
What is he saying? Hang on, come on back up here. Wait a minute. Come here.
Your Honor, if I may, I believe he was, when he was referring there, he's referring that he wants somehow the federal agencies to be involved in this.
You can make your complaint with whoever you want. I'm not subpoenaing the federal agents.
I cannot hear him.
He says you can make your complaint to whatever agency you wish.
You can make your you can make your complaint with whatever agency you want. I'm gonna listen to this testimony with respect to these 3 civil infractions, and I'm gonna make up my mind as to whether or not you committed those civil infractions.
I know, but the right.
Period.
Spot.
Period. That's it. And we're gonna do that May 26th at 1 o'clock, okay? That's the best I can tell you. If you wanna make complaints with other agencies, have at it.
Yeah, but
I don't have any.
federal agents, they can see right there in the
Sir.
spot, they can charge you. In the spot, you know, she need to believe. Not talking, but just she, then they believe.
Time out.
At this point, the courtroom exchange reaches its most intense stage. The defendant refuses to let go of the idea that federal authorities should immediately become involved, while the judge repeatedly explains the limits of his authority. Frustration starts to show on both sides as the same arguments circle back again and again. The judge makes it clear that his role is to evaluate the traffic-related evidence and nothing more. What makes this segment so compelling is watching the gap between expectation and reality play out in real time. The defendant believes the judge can solve everything, while the judge insists that every decision must follow established legal rules and procedures.
Who you think you are?
Well, you judge.
I don't know who you think you are.
You judge, you can do everything.
No, I have rules and I comply with the rules. I'm a judge, I can do anything. Are you? May 26th, 1 o'clock. May 26th, 1 o'clock.
1 o'clock.
Louis Lozon.
Thank you, Judge.
I had written this on here because I didn't realize it was.
Okay,
something.
thank you.
Sorry.
That's okay.
26W842-403. Your name?
Luis Pizan.
All right, you're gonna plead to impeding traffic, right?
Yes, sir.
All right, responsible or not responsible to that?
Responsible.
All right, I'm gonna accept your plea. 160 is your total. 160.
You don't have to pay that all today.
How much do you have today?
$80.
You pay 80 today. When could you pay the rest?
Sometime next week.
I'll make it May the 25th or May the 22nd. How's that? That's a week from Friday. So you pay 80 today, the balance by May 22nd.
Second.
Thank you. Okay, you're all set.
You have a great day, Judge.
You too, thanks. Danielle Anderson. I'm talking loud now because you wanted me to keep my voice to it. Danielle Anderson, 26B150617. How are you?
Great, have a good.
Your name?
Danielle Anderson.
All right. Let's see here. So you're going to plead to impeding traffic, true? All right, to that charge, responsible or not responsible?
Responsible.
All right. You got a clean record, 150 is your total. You're all set, cash your end of the hall to your right.
Thank you.
Have a great day.
Slide.
All right, so you're going to plead to impeding traffic, correct? There was an accident, minor damage and no injuries to that.
After the heated confrontation, the courtroom returns to a much calmer rhythm. One by one, defendants step forward, accept responsibility, and work through their cases without conflict. The contrast is striking. Instead of arguments and accusations, these interactions focus on practical solutions, payment arrangements, and quick resolutions. The judge moves efficiently through the docket while still taking time to explain options and deadlines. This segment serves as a reminder that many courtroom proceedings are resolved through cooperation rather than confrontation, and it highlights how dramatically different outcomes can look when both sides stay focused on addressing the issue at hand.
Charge, responsible or not responsible? I'm gonna accept your plea. 195 is your total, and you are all set. Have a great day. Thank you. All right, to that charge of impeding traffic, responsible or not responsible? Okay, you're all set. 150, cashier into the hall, and the original charge is dismissed. Good luck.
Thank you.
You're welcome. Joy Elizabeth Maldonado, 26T648121. Your name, ma'am? Oh, this was just issued as a warning, right?
Yep, so,
They shouldn't even have filed this.
and then listen to you, I had to pay $160.
Well, we're gonna return it.
That's a good thing, thank you.
Because you went into default is what happened, and that's what the court rules say. When somebody goes into default, you have to pay a bond equivalent to that.
The officer didn't even get me anything written or a ticket. I mean, I just got this thing in the mail that said I had to pay it.
I understand. I'm gonna go ahead and dismiss it. We'll return the bond, okay?
Thank you.
There, you can go down and talk to them. They're not gonna be able to do it today. They're gonna send you a check, okay?
Thank you.
Have a great day. Good. You're gonna plead impeding, right?
Yep.
Okay, good enough. Responsible or not responsible?
Responsible.
I'll accept the plea. 170 is your total. Cash your end of the hall to your right, okay?
Thank you.
Have a good day. How you doing?
How are you?
Your name?
Bowen.
You're gonna plead the impeding traffic, right?
Correct.
Responsible or not responsible to that? All right, 155, cash your end of the hall to your right, and you're all set. Good luck. Have a good day. Philip Allison, come on up to the podium, 26B150081.
Good morning, Your Honor.
Good morning. These operating while texting are not good. You're gonna plead the impeding?
Just when everything seems routine again, an unexpected twist changes the direction of the proceedings. A woman explains that she never received a written ticket and only learned about the matter through a notice in the mail. As the judge reviews the circumstances, it becomes clear that something may have gone wrong in the process. Rather than forcing the case forward, the judge quickly acknowledges the issue and orders the matter dismissed. It is a brief but important moment that demonstrates how courts are not only responsible for enforcing rules but also for correcting mistakes when the facts show that a defendant may have been unfairly placed in that position.